just saw this memo.
Call this special meeting of the Town of Rhinebeck Planning Board to order. There are two matters on our agenda tonight. The first is to assess the environmental assessment form from Red Wing Properties for the special use permit they have submitted to the Town Planning Board to permit them to continue to mine within the 37.5 acre mine they currently have, and add to that a 9 acre lake they're going to mine on the site that DEC approved back in March of last year. DEC has approved their renewal of their mining permit for this mine to run until 2019, for 5 years. So DEC has already issued their permit, but in order for them to use town roads, hours of operation, things like that, they need a special use permit from the town of Rhinebeck, which is what they have applied to right now. So I think the first order of business is to go over part one of the EAF, which you should all have in this lovely bound thing here. If we don't, we're in big trouble.
That's got to be this big one. This is from December, is that right?
Let's see.
Look at this one. This is the smaller one. This is the response. This is the response.
Don't have it. But we had the EAF part one. Is it in the file?
Here it is. It's in the back pages of the, it's the last item in the bound volume.
Okay. It's not in the table of contents.
No, it's the last item in the bound volume. It's,
The big fat one. Oh, here, bring it.
Huh? Well, it's the mining permit application.
it's behind the mining permit
Right.
application.
Okay.
I'm not sure what that was, December.
Has everyone been able to locate this?
Yeah, we got it here.
All right.
You
Okay.
know, it's a thick one like this.
We also,
But I don't see anybody with it.
I'm sorry?
I don't see everybody with it.
It's,
Oh, okay.
And then this is the response
That's
to the question.
That's the reply to comments that were made at the last meeting.
correct. Okay.
I'll share.
Okay, I think as we go through this, I think page one of site description, I think is relatively accurate. I think that under number 11, does project site contain any species of plant or animal life that are identified as threatened or endangered? I believe that they need to update this TES report dated June 10th, that one Blandings turtle was found in a wetland adjacent to site. Actually, 2 have been found. And if you'll look at the mapping that they did under the under the title, under large-scale map superseded by those found on August 28, 2012, you can see some of the where they found, I believe you will see where they found some of the turtles. This is where they were finding. The note TES indicates tracking performed by TES Inc. And that's the little red dots that you're seeing in those areas. And those are Blandings turtles that they found and then they tracked. So the report here needs to be updated at least to 2012, and the DEC has requested further updating. DEC is also somewhat concerned that scientists were not used to do the tracking, and DEC wants to be on site the next time this further review work is done, further study work is done. Project site plans, community neighborhood, no. Scenic views, no. Streams, the Landsman Kill runs through that portion of the property. Lakes, ponds, wetlands. I believe that in addition to RC 25, I believe also, into that area, is RC 30. And I think, Joan, do we have the maps that are they in? The maps that Jay Dean copied this afternoon? Okay. Aha. Okay. What I can do is just circulate these so you can all take a look. Basically, these are maps of the site which show the aquifer, the Type 1 aquifer, Blandings Turtle Conservation Zone, farmland soil map, Kinland Priority Conservation Area, the significant habitats as mapped by Hudsonia, steep slopes, the streams running through, you can see Landsman Kill, vernal pool conservation zones, and DEC and the NWI wetland. So let me start this down here. You can take a look through this. You see the area is significantly constrained by certain natural features. It's very lonely down there all by yourself. Maybe I don't have that with me. At any rate, as you can see, as these maps come down, there is significantly impacted by DEC wetlands and also NWI wetlands. The area that is currently being mined does not include any of these wetland areas. The area proposed for the 9-acre pond, lake, subsurface, subaqueous mining does not impact directly any of these wetlands, although some of the mining area does, I believe, impact the buffer areas of those DEC wetlands. Okay. As it goes on to project description, total acreage is 241 acres, 38 is the existing mine. 303 acres to remain undeveloped. The reclamation they discuss, the entire mining project is governed by New York State's Mined Land Reclamation Law, which DEC administers. And as part of any permit given for mining of this sort, a reclamation plan and schedule also has to be submitted and has to be kept to. And DEC is responsible for seeing that that happens. As we go through this, most of the questions don't apply. They tend to be questions dealing with development of one sort or another, be it residential, commercial, something of that sort, as opposed to this particular activity. Okay. Going through part one, given the existing activity, nothing at the present time jumps out at me as being necessarily an issue with the current application that's before us. I think the thing we need to be clear on, because I know people are discussing an expansion application that Mr. Kinland originated about 4 or 5 years ago to expand the mine to cover some 100 and something acres with a roughly 81 or 82 acre lake within that subaqueous mining to take place. And I think that's what most people are concerned about, understandably so. I just want to make sure everyone understands these are two different applications. The other application is still before DEC. They have not accepted it as complete. They're not satisfied with the information they have received in terms of the natural resources and the impact on habitat, things like that.
That's for the larger.
That's for the larger. As I said, DEC has already, they have already permitted the continuation of mining within the 37.5 acre existing mine with the addition of a 9 acre lake to be created through subaqueous mining.
Marco, I think it's important to point out that DEC initially took that position in terms of the permit approval in March of last year, at which time they also declared, DEC declared from its perspective that the action was an unlisted action and there would be no significant impacts on the environment. And of course, I think as we've discussed in the past, DEC also included the language in the permit at that point in time that acknowledged that other involved agencies might have a different opinion with respect to the environmental significance. DEC, that was the first action taken by DEC in March of 2013. Then technically, because that permit only extended till December of 2013, DEC then renewed that permit in January, and that renewal was treated as a type 2 action, was a ministerial action.
And so that no SEQRA review was required under state regulation. There are a couple things here that I think might be helpful for us to go over, and that's basically Mr. Griggs provided us with responses to the questions that were raised at the public hearing earlier this month, and I think a couple of them might be helpful. One was a question about blasting, and there will be no blasting at this site. Number of questions about trucks, sizes of trucks, where they're going to go, the routes they're going to use, things of that. As they're stating here, and these things we will be placing into the special use permit should it be approved as conditions of the permit. No change in amount of truck traffic or scale of operation is proposed, which I think we want to include as one of the conditions of the special permit. Trucks will continue to enter and exit the site through the existing northern exit and travel north on White Schoolhouse Road to New York State Route 308. In other words, they will not be turning, I think they meant to turn north. They will not be turning south and going down towards Slate Quarry Road. I know that Kathy Kinsella, our highway superintendent, had concerns about the bridge that goes over the water area down there, the stream by the barns, by some of the Labatsky property. Clearly was not designed for trucks of this sort, and I think her concern was that if indeed they were going to use that as an exit down to Slate Quarry Road, those bridges and culverts would have to be looked at and probably reinforced before that could happen. The other two soil mines on the site, on the Labatsky property and the Vonderlees property, all turn south and go out on Slate Quarry Road. They do not go over this bridge. About 20 trucks enter and leave the site each day when the site is in operation. Trucks will be limited to no more than 10-wheel, 12 cubic yard capacity as per town's recommendation. The same size truck that is historically operated at this mine and at the other two mines on White Schoolhouse Road. Red Wing has proposed to build a new entrance road in the future, but does not yet have DEC approval to do so. I do not know where that road is. I have not.
Nor is it part of this application.
Nor is it part of this application. The dust concern, basically, the mine will be operated in the exact fashion it's been operated by Mr. Decker. I believe he's going to continue to operate it as it has been in the past, so that should not require any greater dust or dirt being created. The noise and the visual, there was clearing on 9 acres just to the south of the existing mine, which is still the subject of a DEC complaint investigation. They're still not terribly happy with that. That area is not part of this application. That area is not going to be mined. Indeed, we do have a copy of a contract with Mr. Vosberg, who is going to farm that for his, I believe, cattle operation up in Red Hook. And so it has been disc. It is going to be, whether it's field corn or hay, I don't know. But that's what's going to happen, and the contract runs for 5 years through 2019. There's a discussion of the comprehensive plan here. Actually, quite frankly, I would have to take exception with Mr. Griggs' statement that the town's comprehensive plan recognizes the need for mining. Basically, the comprehensive plan speaks about mining twice, basically saying it should be restricted to the existing life of mines as they currently exist. It does not speak to the desirability or importance of mining. The other discussion he has here may well indeed be valid, but it's not in our comprehensive plan to encourage mining of this sort in the town. Change in size of operation.
Hold on, he's, pardon?
I just want to say, can they go outside and talk while I'm trying to listen to you?
They'll be, they understand, they'll be good. Change in size and scale of operation. There's no intent under this application before us to increase either the scale or the size of the mine. Granted, they're going to be doing subaqueous mining now because basically most of the material, the sand and gravel that's above water, has been pretty well played out on this mine site. So this is why they are proposing to go subaqueous. Wildlife, basically within the existing mine site itself, we have no record of different wildlife in there, although it's entirely possible you would find turtles, things like that, laying eggs, things of that sort, but that hasn't happened. Property values, that's that's another issue that one could say, since this mine has been here at this size for the last I don't know how many years, the impact on property values is probably a little difficult at this point to assess. I think the greater concern is that expansion of the mining in this area is, I think, the greater concern of potential impact on property values. There was some discussion of a public park at the site. I don't think the town, quite frankly, they've made it clear to the planning board over the last I don't know how many years they are not interested in the planning board taking land for public parks, public uses, things like that. And I think they feel they're fairly well burdened right now with trying to develop the Thomas Thompson Sally Mazzarella Park. I don't really think they would welcome another opportunity for another park.
Once again, not part of this application.
Correct. The groundwater impacts, in terms of, I think it's more the subaqueous than any other concern right now. Basically, it is a sand and gravel type 1 aquifer. Pollutants, contaminants can travel very quickly through this material, although it does offer some protection to the water below. When you are mining down into the aquifer itself, you are exposing the aquifer, you are bringing it to the surface, and surface waters traditionally are more susceptible to pollution than our groundwaters, which have at least some natural filtering capacity. The size of this lake, I think in DEC's view, was not overly large to create necessarily a negative impact on the aquifer. I know we have 2 other subaqueous mining operations of a limited scale at the Lavatsky property and Richie Vonderlees. And as I say, they have a limited scale, and I think scale is probably the real question here. How big do you get before you maybe do have a negative impact? DEC clearly feels that the 9 acres would not have a negative impact upon the aquifer. The hours of operation will be controlled by the town. They will be, as they have been traditionally, 7 to 5, Monday through Friday. They were allowed, I think, 4 Saturdays a year, and then there are holidays that they're not permitted to work, and Sundays, of course, they're not permitted to work. The Blandings turtles and the study that was done, they were found outside the existing life of mine, in wetlands and areas surrounding wetlands outside of the existing mine. Conservation easement. The town is not in a position to require a conservation easement of someone requesting a special use permit for extractive operations. That's just something that we do not have the authority to do. And ground disturbance outside permitted area, there is indeed a complaint investigation still undergoing by DEC of that 9-acre grubbing, clearing and whatnot, which apparently now is going to be used for agriculture. There was some I would say confusion in one a letter that was sent to DEC that possibly that would be serving both agriculture and possible future mining, which of course the future mining, they're not permitted to do that on that site. It's currently under a SEQRA review for the expansion they want, and they are not entitled or allowed to take any actions related to the mining activity they want to do there. So the clearing, I think DEC is trying to decide exactly why it was done and what, if any, harm was done. And we do indeed have the permit The DEC has approved, and its expiration date is the 23rd of January 2019. And with the conditions, basically, they are the conditions that are similar to the ones that were under the previous permit that just expired at the end of last year. You will notice that there's understanding that there are turtles in the area, so there is a significant section in here requiring installation of turtle fencing, inspection of turtle fencing, maintenance of turtle fencing, inspection of daily excavation area. DEC is quite aware of the potential for wildlife in this area that is both rare and of special interest to New York State. I don't know that there's anything else in here that we haven't seen before. I don't know if members of the planning board have any questions on this. Granted, our authority here is greatly limited as far as permitting is concerned. Anyone have anything they'd like to?
I think for the public record, this response from the applicant is available to the public if they
Yes.
want to look at it at any time here in the town hall, right?
Absolutely.
Okay,
The
just so
enti-
anybody wants
Yeah,
to
oh, the
know.
entire file, application file, is available, no question, absolutely.
I think would beyond that, be instructed for the to tell the public that public will have an opportunity also, if they review that record in the interim, they'll have an opportunity to comment on that response at the continued public hearing, which is scheduled for March 3rd.
March 3rd, yes. We will be having the public hearing recommence at that time. Any other thoughts by any members of the planning board? I think the other point I want to make so that people do understand this, because I think there's been some confusion about this. New York State DEC controls mining within a permitted mine site. The town of Rhinebeck has no control over that except over hours of operation and use of town roads, things like that, size of trucks, things of that sort. The town does have the authority, and I have a number of court cases which verify this. The town has the authority to decide where in a town mining will take place or if it will take place. The town has the legal authority to ban it outright if the town chooses to do so. Times change. It may be time to revisit what's happening out there. It may be time to take another look. But as far as actual permitting of an existing mine that has a DEC permit to continue to operate, we're very, very limited in what we can do as a town and as a town planning board. Anything else I should say that anyone would like to hear? I think from a SEQRA standpoint, given our limited authority, I don't see that we're going to pause deck this. From our standpoint, I don't know what basis we would do that.
I've gone through a Part 2 EAF and really approached it on a very conservative basis. And even on that basis, identified no potential adverse impacts that could be considered large and significant. Lacking one or more of those, there is no opportunity to issue a positive declaration, which I guess is the same reason that DEC reached its conclusion several months ago that this, what they called a renewal, what you're calling a new special permit, but dealing with that same work within the existing life of mine area and essentially the excavation of that pond, doesn't create any adverse impacts. That's got nothing to do with the other matter that's before DEC. The only other thing I'd suggest is that one very positive response that has come forth from the applicant since the last meeting is the applicant's acknowledgement and acceptance of the same conditions that were previously in the town's special use permit with respect to hours of operation, days of operation, location of truck movements, size of trucks, et cetera. I would just note that the conditions that were imposed by the town at that point in time and are likely to be imposed, or certainly going to be imposed again on a new special use permit, are over and above conditions imposed by DEC. DEC's permit does not deal with the matter of the truck limitations. And with respect to the matter of the hours of operation, DEC's statement regarding hours and days of operation is less limiting than the town position. Consequently, if you do reach the point of decision on the special permit, I think it needs to be clearly stated in the special permit that the stricter of the two conditions prevail. You're referencing the state permit, but the stricter of the conditions as they exist in the town permit or the DEC permit do exist. With respect to what you said about the authority of the town does have a role with respect to the land reclamation plan, but that role is limited to concurring that the use that the land would ultimately be put to upon completion of the land reclamation plan is a use that's acceptable to the town.
Yes.
And in this particular case, absent a specific proposal here for public use, for public park, which would be not acceptable, presumably, the proposal is for open space agricultural use, private open space agricultural use, which of course is consistent with your master plan.
And potentially residential use. It doesn't
Right.
rule that out.
Exactly. So that's that's kind of a capsule of where it stands. The public has indicated before a response document that can be reviewed. The board has the obligation of conducting continuation of this public hearing, and until that additional public comment, if any, is on the table, the board probably at this point should not be in a position of prejudging the application and really should continue this discussion until after the continuation of the public hearing.
And wait at the same time to make our secret determination.
Exactly.
Yeah. Everyone sort of on board with that?
Sounds good to me.
We've already rescheduled the public hearing for March 3rd. So at that time, we will be taking public comment, and we will be revisiting this particular issue. And I do want to emphasize that all the material on this project are available in the clerk's office, and they are open to the public. You're more than welcome to come and take a look at any of this. And there is a fair amount here, as well as the maps we've created and things of that sort.
And this item is the first item on the public hearing agenda, 6:35 on March 3rd.
Yes. The next item on the agenda is the finding statement for the final GEIS for the Grasmere project.
Just back up one step. First item on the agenda is proceeding to the finding statement, and that is the consideration of comments, the board's consideration or discussion of any comments that were forthcoming based upon the issuance of the notice of completion of the final generic impact statement. Bottom line is there is no planning board discussion because there were no comments submitted by either involved agencies or interested agencies or persons prior to the 4 o'clock deadline for comments, written comments, 4 o'clock today. So there are no comments, so that dispenses with that issue. The second item does relate to the completion of the SEQRA process and ultimately the finding statement, and that is the consideration of the specific, not specific, but at least on a conceptual basis, the boundaries of the proposed 250-acre parcel. There's been a lot of discussion through the SEQRA process of the applicant needing to create a 250-acre minimum parcel as a prerequisite to a special, for the issuance of a special use permit for a country Inn 2. The issue that's come up, or the question that's come up, knowing that the Mensch family holds some 525 or thereabouts contiguous acres in that area, is which 250 acres are going to be dedicated to this particular use. And as we've discussed previously, those 250 acres are going to have to be set aside, and they'll be set aside ultimately through the subdivision process. What hadn't happened before this evening and will be happening now is essentially the equivalent of the sketch plan conference with respect to that, the configuration of that 250-acre parcel. And I think, as you're aware, the only thing that really happens at a sketch plan conference is that the planning board determines whether or not, on a conceptual basis, the configuration of a parcel that is proposed makes sense. Does it create, does it meet the requirements of the use that's proposed, and does it create any obvious problems with respect to how lines are drawn in terms of perhaps dividing a piece of land with a line that cuts through a water body or something of that particular sort. So the applicant is here for that purpose, as we know. Joan has indicated that the applicant has submitted the requisite sketch plat. It's not really an application, it's a request for sketch plat consideration, paid the necessary fee, and the board's position is simply one of reviewing the proposed configuration, saying whether or not it is a reasonable configuration that would then be pursued through a subdivision plat application, just as site plan and everything else is going to be pursued down the road, at which time a survey map and whatever would be presented. That's essentially the background. That then becomes a lead into the findings.
So Jonathan, I think you're up.
Okay. I've got copies here for everybody.
Thanks, John.
In color.
Yeah.
Thank you.
Well, I guess the other thing I should say is I have reviewed the plan previously.
This, I think, only 11 by 17. We've got a larger map which doesn't show the delineation, but if people can, hopefully, maybe I'll use the microphone. That'll be easier.
Yeah, and you can walk around with that. I've been told there's plenty of...
Oh, okay. Sure.
Hold it up for you.
Yeah.
Bring it over here so we can see it on the.
Oh, yeah, okay, great.
So like someone at the fight, you know, round 3.
Yeah, around everywhere. But I think, as the board members, you can probably, we've been through this enough, you can probably follow where the most relevant parts are. But this is the old manor house right here, and here are the stone barns. And this right here is the old estate area, which we're calling the development zone, because that's where the rehabilitation is going to take place. That's where the new structures would be built. And as we've explained in the past, the intention was always to contain the development up in this area and then preserve the view sheds. So for the sketch plan submission that you all have in front of you, the idea here is to do exactly that, is to include as part of the 250 acres this area, which is the estate area, and then the view shed across the main field, as well as the view shed back over towards Mill Road. And so everybody can see it, this is Route 9 up here. Our property actually extends down here as well. This is Meg Crawford down here. There's a tail on the property as well, which is the area that's outside of the 250 acres. But the 250 acres really covers the areas that we had set out to preserve.
Any questions, members of the board? I mean, it certainly seems fitting in with what you've been proposing to do.
Yeah, and as we go through the site plan process, if there are the things that come up, we can certainly make modifications to this. I mean, I'm looking down here, we've got, entrance number 1 is down there. If we need to jigger the line a little bit, we can certainly do that. If things come up where, this was really, the idea was to show the 250 acres and then show the areas that are protected.
I guess what we're looking for is a consensus by the board that indeed this will satisfy the 250-acre requirement set aside for Country Inn 2.
Yeah, I think the board ought to make a couple of points in doing that, just because of how it relates to the SEQRA position. I think you know, as you say, the board would be in a position to consider the endorsement of the sketch plan as doing two things. One is being consistent with, as the applicant, I believe, has indicated in a cover letter, being consistent with the objective of integrating both the estate area and the main view shed over the hay fields or the agricultural fields into the protected parcel that is the 250-acre minimum for the country Inn 2. And secondly, that this particular configuration satisfies the basic zoning requirements for a lot in the RA 10 district, in that this configuration does provide frontage, which would not currently be involved, which is not currently held by the estate parcel,
Correct.
by including the Route 9 frontage. So I think there are a couple of important points that need to be made. Beyond that, this sketch would then be integrated or incorporated in the finding statement. And considered as a basis for, ultimately, for an application for subdivision plat approval.
And sufficient to carry out the necessity of representing the 250 acres for the finding statement.
For the special use permit.
For the special use permit, but also for the finding
For
statement.
the finding statement, as well as the
Right,
application for
right.
special use permit.
Right. Did we all get that? Perhaps a motion to that effect would be helpful,
There's something along those
something
lines.
along those lines? Joni, did you get all that? All right. Could I hear a motion?
So moved.
Second. Second. Further discussion? All in favor?
All right.
Okay, so we now have 250 acres.
Okay.
Now,
Now,
you
I
want to
guess-
tell them, you want to tell them what you sent them, or you want me to tell them?
I'll tell them what's being sent. There are a couple of very, very minor modifications that need to be, well, fewer modifications that need to be made than I thought would be the case, not knowing whether or not there would be any comments that we would have to be discussing on the FGIS. But as authorized by the board at the last meeting, I have prepared a draft finding statement for review by the board and ultimately for consideration of adoption at your next meeting on March 3rd or some subsequent date. I have to make a couple of minor modifications or adjustments in the draft finding statement to incorporate specific reference to the endorsement of the 250-acre configuration, and add one other paragraph that has come to my personal attention, my own attention. But other than that, the draft of the finding statement has been prepared for your consideration, either later this evening or the first thing in the morning. You can expect to see, I'm talking to the board members, you can expect to see an email transmitting that particular draft. The draft is either, just so we know, you'll make sure that you have it, it's either 101 or 102 pages in length. It may be 102 with those little modifications. But that is the draft of the finding statement. And with your concurrence, asking for this, with your concurrence, I'd like to be able to send a copy to the applicant, not for comment on the findings, but for comment or for review as to whether there are any factual errors that I have made in drafting the document in terms of describing the project. Describing the project or describing the impacts, such as the specific acreage of wetland encroachment that's occurring or something of that particular sort.
Art sent me an advance copy of this over the weekend, and I read it. I had 103 pages, but I read it. absolutely covers what we have discussed, what we have looked at. The questions that came up, I think, in good detail are all referenced there. The appendices are then referenced for if you want further details about any of the different issues that came up. My own view, having read it, I would certainly endorse the planning board adopting that. But you're going to have 2 weeks to read it and go over it and decide what you want to do on March 3rd with it, if you have any other questions, things of that sort.
Are you going to read it verbatim to the public?
I am not.
After consideration of adoption by the board, if the board adopts, then it will become a document that will be obviously posted on the town website and circulated to all the agencies as required under SEQRA. The board will see in going through the draft that besides satisfying your final SEQRA obligation, which is to issue findings, the document is structured in a way that is essentially the springboard to your next two necessary actions in this particular project. One is the matter of the issuance of a statement of consistency under the LWRP, and that is one of the reasons. It's about 15 pages of the 100. And secondly, there is a section in here that goes on a point-by-point basis through the special conditions that are associated with the special use permit for a country N2. So essentially a lot of the framework for both the statement of consistency and for ultimate consideration of a special permit is included within this document. It needs to be restructured a little bit, but it's basically the framework is there.
And at our March 3rd meeting, in addition to addressing adoption of the finding statement, we will also be reopening the public hearing on the special use permit.
I guess technically it'll be the matter of scheduling the hearing. We'll approach that on a de novo basis in that when the original notice of circulation of the acceptance of the DGEIS, the draft generic impact statement, included the mention of the public hearing. That particular portion of the notice requirements that related to the special hearing were not met at that point in time.
Okay.
And technically, the project has changed since then because the project has gone from the matter of full access at 3 locations now to only an entrance only at Mill Road, coupled with the fact that we now can more specifically say it's this 250 acres as opposed to some potential 250 acres of the 500-acre holding. So that it'll be we'll deal with it. We'll structure it for you procedurally as a new action.
Okay. So I think the only thing we have left to do tonight is consensus of the board to allow the applicant to have a copy of this, as Art says, just to fact check it. I think that's not a bad idea.
Absolutely, it's the right thing
Everyone
to
okay
do.
with that? So, I mean, why shouldn't they suffer and have to read it too? You know? So,
They can read it to the public next month.
We can
I think
take turns.
I like that
Tag team.
idea. So you guys definitely will be given this to liven your nights. I don't think there's anything else we had to do in terms of the finding statement this evening.
I think that's all you have to do this evening.
I think that those are the agenda items we had tonight. We limited to those 2 specific issues.
You have a heavy meeting coming up on March
We
3rd. There are at least 9 items on the agenda, 4 public hearings and 5 other items.
Now, please check your file. You're going to get this, which is the Astor Tea House Duffy application, and there are a number of other little surprises in there, too. So, just so you're ready to go. Anyone else on the board have anything else they wish to say? Did I hear a motion to adjourn? A second? We stand adjourned at 7:16. And I thank you all for coming to this meeting. I